From the Wisconsin Institute for Law and Liberty, joining me on the phone this morning is Associate Counsel Cory Brewer. Good morning, Cory. How are you?
Good morning, Meg. Thank you for having me on.
Well, I am delighted that you are joining me on this early Monday morning. It's always tough, as I said off air, to kick things off on a Monday morning. But hey, why not? We'll talk about this. And as I said to you off air, it's so frustrating that we have to, and really those of us who are common sense, critical thinking people need to sue our government our government entities in order to get them to adhere to the law. And there's a new case that Wisconsin Institute for Law and Liberty is, you're acting on behalf of School Choice Wisconsin, et cetera. And can you talk a little bit about this lawsuit against the Department of Public Instruction here in Wisconsin?
Yes, so we filed suit against DPI related to what we're calling an application perfection rule. So essentially, DPI has promulgated rules affecting the application process for families to get their children into the parental choice program. So this affects what residency documents will be affected. How perfectly does the name on a residency document have to match the application? How perfectly does the name on the application have to match the residency document and what's, the legal name? You can't use a shortened version of the name. And the issue with this is that DPI has created these rules about perfection on the parental choice program applications, and they've created them without going through the rulemaking process. So our state law has a process for promulgating rules, and these rules that DPI has now enforced, they have the effect of a child could lose their seat in the choice program. Again, the choice program created by our legislature, it's supposed to be easy to use as an alternative option for parents to have their kids go to another school if they qualify. And DPI has just made it so burdensome for families, for schools to comply with, and they've done this without following the process in our state law. So there are a few examples that we've heard of in kind of prompting us to hold DPI accountable and file this suit. For instance, if a utility bill, if you live in, say, Sheboygan Falls, and your utility bill maybe says Sheb Falls, that is not acceptable. That is not a perfect match. It cannot say Sheb Falls. It has to say Sheboygan Falls. So if that residency document says Sheb Falls and you don't correct it in a way that the DPI says you need to correct it, then the application is ineligible and child loses their seat in the choice program. So we've heard of a myriad of examples similar to this. It's not allowed by our state law, so we're filing suit to hold DPI accountable.
Well, not to get off topic, but boy, it's interesting how the left is all about perfection when it comes to a school choice application, but they have no problem with curing ballots. After the fact, when someone returns an absentee ballot and it maybe has Sheb Falls on it, you think they're going to believe that that's going to say Sheboygan Falls? Of course they are. Well, we were talking off air, and I was trying to think of the right adjective to describe this, and it really, it's not surprising how far the left will go to punish those of us who believe in school choice, but the word that I was trying to think of, Cory, off air was vindictive. And I mean, this really seems to be, I said punitive or retaliatory, but this goes beyond just being complete on an application. This really appears to me to be targeting parents who want to send their children to a school other than the traditional public school.
I absolutely understand that frustration, and that's what we've been hearing from School Choice Wisconsin Action, what they've been hearing from their member schools. It just, even if a child maybe doesn't experience the most extreme outcome and lose their seat, the schools have to spend time and resources every single year to comply with these regulations that DPI has enacted on their own. They didn't follow the rulemaking process, and now as a result, schools have to try to comply. Parents are often confused, maybe even deterred from applying at all. And we have heard of instances where children will lose their seat in the school if the application is non-eligible according to one of these application perfection rules. So oftentimes when that happens, they don't find out until October or November. So the child is already in school. They're maybe doing really well. They're getting, to fit in at the school. And then they'll find out in November, you know what, your application to the parental choice program, that only, maybe so for a legal name, the name application, for example, and this often affects minority families who culturally maybe have many names as part of their legal name, but maybe they move here or maybe they've been here for a while, and just for ease, they use on all of their documents
like a
their
nickname,
first and last name.
Mm-hmm.
And everybody knows that that's who that person is. Nobody's trying to commit fraud. There's no question about who it is. But because it doesn't have their full legal name, the application is ineligible. And if they don't correct it, the child loses their seat. And not only does the child then have to find a new school to attend or be homeschooled, virtual schooled, but it's a financial burden on the school as well, because they thought they were going to have this, the voucher amount for that student. And then they find out a few months into the school that, no, their application didn't match perfectly. So that child loses their seat, and you lose the amount of money that you thought you had to educate that child.
I'm just so glad that there are parents, obviously, that came forward to essentially blow the whistle on this, because I would say I was going to ask you about that, about some families may just think, oh, they may not have the courage, I guess, to speak out, or they may not even have the inclination, believing that, oh, well, the government, because government said my child can't be in the school choice program anymore, and they willingly accept it, and I would imagine that that's the objective, and that's what DPI is taking advantage of, is that there will be parents that will just throw their hands up and say, oh, okay, well, government wins on this one. And I look at it again as it's essentially like the weaponization of the application process, and they're using it. They're holding families and children hostage because of some sort of rule that they've changed without perhaps properly notifying. Obviously, they're not following the process, but without even notifying parents that that's what they're requiring.
Right. They're creating these barriers. They're illegal barriers to get into the program, and the program, the parental choice program, was not designed to be this difficult to apply for, to get a seat in. These families, these children, they only want to apply as if they were applying to their local public school. It shouldn't be this hard, and it's confusing. And thankfully, there's School Choice Wisconsin Action, and a lot of these schools, they do whatever they can to help these families. They're spending so much time to help these families comply, because, one of the ways DPI issues these rules is through informal bulletins, and they'll have charts on them and say, okay, if you're abbreviating your street name and you live on North 5th Street, you can put N 5th. But if you live in the city or town of North Prairie and you put N Prairie, no, that is unacceptable. It doesn't match. So these schools are using these bulletins, what's okay, what's not, what residency document is okay, what's not. And, sometimes, and this actually just happened, DPI will change them. There was an issue with a shortened city name with Wisconsin at the front, and the utility bill said Whisk. Well, that's unacceptable, or it was. And then, these schools in School Choice Wisconsin raised the issue and said, really? Really, everybody knows that means Wisconsin, and now it's acceptable, but only in one city. It can change all the time. It's done on an ad hoc basis without going through the rulemaking process, and it creates barriers to the parental choice program, to parents that are just trying to find the best way to educate their kids, schools that want to educate kids, and it was not designed to be this difficult to just apply for a seat.
Yeah, I wonder if they'd use the same strict guidelines if a child were moving into a public school district and abbreviated their street name or their city name or even used a nickname. I wonder if they deny them access to the public school as a result. Of course, these are all rhetorical questions. Well, Cory Brewer, thank you so much for joining me this morning. Do you have confidence that this is going to get resolved in an acceptable manner for these parents?
We do, and I won't go into it too much here, but we represented some schools before the pandemic related to virtual learning, and there was a similar administrative rulemaking claim in that case where public schools could use virtual learning, but for private schools, DPI was saying no,
Oh,
you may
give me
not
a
use
break.
virtual learning, and we were successful in that case. So we're really hopeful and really optimistic that we'll have a similar result here.
Precedent setting, I hope. Well, thank you again from Wisconsin Institute for Law and Liberty, Cory Brewer. Thank you so much for joining me this morning. Please keep in touch and let me know how this goes. There's so many active cases, I guess, against our government. It's hard to keep track of all of them.
Thank you, Meg. We'll absolutely keep in touch.
Have
Have
a
a good
great
day.
day. Thanks.